Are you feeling overwhelmed by the probate process and wondering how to finally bring it to a close? Finalizing probate can seem like a daunting task, but in this video, we'll guide you step by step through resolving remaining disputes, distributing assets, and filing that all-important final report. Whether you're an executor or a beneficiary, knowing how to handle the closing phase of probate can save you stress, time, and potential legal complications. Ready to wrap up the estate smoothly and efficiently? Stay tuned because we're diving deep into everything you need to know to close the estate like a pro. Resolving any remaining issues and disputes. Once the probate process is underway, it is not uncommon for various issues and disputes to arise among interested parties. These issues can range from disagreements over the distribution of assets to challenges regarding the validity of the will. Resolving these disputes in a fair and efficient manner is essential to ensure the smooth administration of the estate. Below are some common strategies for addressing remaining issues and disputes during the probate process. Mediation and negotiation. One of the most effective ways to resolve disputes in probate is through mediation and negotiation. Mediation involves a neutral third party, facilitating discussions between the parties involved to reach a mutually acceptable solution. Negotiation, on the other hand, involves direct communication between the parties to try and come to a resolution. Both methods can help avoid costly and time-consuming litigation. 2. Court intervention. In cases where disputes cannot be resolved through mediation or negotiation, court intervention may be necessary. This typically involves filing a petition with the probate court outlining the issue at hand and requesting a resolution. The court will then hold a hearing to listen to both sides of the argument and make a decision based on the evidence presented. 3. Executor's role. The executor of the estate plays a crucial role in resolving disputes among beneficiaries. It is important for the executor to remain impartial and act in the best interests of the estate. The executor should communicate openly with all parties involved, provide transparency regarding the estate's assets and liabilities, and seek legal advice when necessary. 4. Legal counsel. In complex probate cases involving significant disputes, it is advisable for all parties to seek legal counsel. An experienced probate attorney can provide guidance on the legal aspects of the case, advise on potential strategies for resolution, and represent their clients in court if necessary. 5. Alternative dispute resolution. Apart from mediation, other alternative dispute resolution methods, such as arbitration or collaborative law, can also be considered. These methods offer a more informal and flexible approach to resolving disputes outside of the traditional court system. 6. Seeking a compromise. In many probate disputes, reaching a compromise may be the most practical solution. Parties involved should be willing to make concessions and negotiate in good faith to reach a mutually acceptable agreement. Compromise can help avoid prolonged litigation and preserve relationships among family members. Resolving remaining issues and disputes during the probate process requires patience, communication, and a willingness to work together towards a common goal. By employing the above strategies and seeking professional guidance when needed, parties can navigate through potential conflicts and ensure a fair and efficient distribution of the estate's assets. Obtaining court approval for the distribution of assets. Obtaining court approval for the distribution of assets is a crucial step in the probate process, ensuring that the estate's assets are distributed according to the deceased person's wishes and in compliance with the law. This process involves several important steps and considerations that must be followed carefully to avoid legal complications. 1. Inventory and valuation of assets. The first step in obtaining court approval for asset distribution is to prepare a comprehensive inventory of all assets in the estate. This includes real estate, bank accounts, investments, personal property, and any other assets owned by the deceased. Each asset must be accurately valued to determine the total estate value. 2. Notification of creditors. Before distribution of assets can take place, creditors of the estate must be notified and given an opportunity to file claims against the estate. This is typically done by publishing a notice in a local newspaper and sending direct notice to known creditors. Creditors are usually given a specific period of time to file their claims. 3. Review and approval of distribution plan. The executor or personal representative of the estate must develop a proposed distribution plan outlining how the assets will be distributed among the beneficiaries named in the will or according to state law if there is no will. This plan must be submitted to the court for review and approval. 4. Court hearing. In many cases, a court hearing will be scheduled to review the proposed distribution plan. The executor or personal representative may be required to present evidence supporting the plan, such as the inventory of assets, valuation reports, and any relevant legal documents. Beneficiaries and creditors may also have the opportunity to raise objections or concerns during the hearing. 5. Court approval and order. If the court is satisfied that the proposed distribution plan is in compliance with the law and the deceased person's wishes, it will issue an order approving the distribution of assets. This order serves as the legal authority for the executor to proceed with the distribution process. 6. Distribution of assets. Once court approval has been obtained, the executor can begin the process of distributing the assets to the beneficiaries according to the approved plan. This may involve transferring property titles, closing bank accounts, transferring funds, and taking any other necessary steps to fulfill the terms of the distribution plan. 7. Final accounting and closing. After all assets have been distributed, the executor must prepare a final accounting of the estate's finances and transactions. This accounting, along with evidence of asset distribution, must be submitted to the court for review and approval. Once the court is satisfied that all requirements have been met, the estate can be officially closed. Obtaining court approval for the distribution of assets in probate involves careful planning, documentation, and adherence to legal procedures. Executors and personal representatives should work closely with legal professionals to ensure that the process is carried out accurately and in accordance with the law to avoid delays or disputes in asset distribution. Handling final accounting and reporting requirements. Once the probate process is near its conclusion, it is crucial to properly handle the final accounting and reporting requirements. This step involves compiling all financial transactions and activities related to the estate and presenting them in a clear and accurate manner for review and approval. 1. Gather all financial records. Start by gathering all financial records and documents related to the estate. This may include bank statements, investment account statements, receipts for expenses, bills paid, income received, and any other financial transactions. 2. Prepare a detailed account. Create a detailed account that outlines all the financial activities of the estate from the date of the decedent's passing to the present. This account should include all income received, expenses paid, assets distributed, and any outstanding debts or liabilities. 3. Reconcile accounts. Ensure that all financial accounts are reconciled and that there are no discrepancies or errors in the accounting. Reconcile bank statements, investment accounts, and any other financial accounts to ensure accuracy. 4. Obtain approval. Once the final accounting is prepared, it must be reviewed and approved by the relevant parties, such as the beneficiaries of the estate and the probate court. Make sure to provide supporting documentation for all financial transactions to substantiate the accuracy of the account. 5. File required reports. Depending on the jurisdiction, there may be specific reports or forms that need to be filed with the probate court or other governing bodies. Ensure that all necessary reports are completed accurately and submitted on time to avoid any delays in closing the estate. 6. Distribute assets. After the final accounting is approved and all reporting requirements are met, the remaining assets of the estate can be distributed to the beneficiaries according to the terms of the will or the laws of intestacy. 7. Close the estate. Once all financial matters are settled and the assets are distributed, the estate can be officially closed. This may involve filing a final report with the probate court and obtaining a final order of discharge, formally concluding the probate process. Handling final accounting and reporting requirements is a critical step in the probate process to ensure transparency, accuracy, and compliance with legal obligations. It is advisable to seek guidance from legal and financial professionals to navigate this complex aspect of estate administration successfully. Closing the estate and discharging the executor. Closing the estate and discharging the executor is a crucial step in the probate process. This section provides a detailed overview of the procedures involved in wrapping up the estate administration and releasing the executor from their duties. Closing the estate. Final accounting. The executor is required to prepare a final accounting of all the estate's assets, expenses, and distributions. This detailed report provides transparency on how the estate was managed and ensures that all beneficiaries receive their rightful share. 2. Distribution of assets. After obtaining court approval for the final accounting, The executor can proceed with distributing the remaining assets to the beneficiaries as outlined in the will or determined by state laws if there is no will. 3. Payment of debts and taxes. Before closing the estate, all outstanding debts, taxes, and expenses must be settled. This includes paying off creditors, finalizing tax returns, and obtaining tax clearance certificates to release any liens on the estate property. 4. Obtaining receipts. Beneficiaries must sign receipts acknowledging the receipt of their inheritance. This documentation serves as proof that the executor has fulfilled their duties and distributed the assets accordingly. Discharging the executor. Petition for discharge. Once all tasks are completed, the executor can file a petition with the probate court requesting to be discharged from their duties. This formal request signals that the estate has been fully administered and can be closed. 2. Court approval. The court will review the petition, final accounting, and any supporting documents to ensure that the executor has complied with all legal requirements. If everything is in order, the court will issue an order discharging the executor. 3. Release of bond. If the executor was required to post a bond at the beginning of the probate process, the court may release this bond upon discharge. This frees the executor from any financial obligations related to their role. 4. Final report. The executor may be required to file a final report with the court, summarizing all actions taken during the probate process. This document provides a comprehensive overview of the estate administration for future reference. 5. Closing documents. Once the executor is discharged, they should retain copies of all closing documents, including the court order of discharge, final accounting, receipts from beneficiaries, and any other relevant paperwork for their records. By following these steps and fulfilling all legal requirements, the estate can be successfully closed, and the executor can be formally discharged from their duties, bringing the probate process to a conclusion. Tips for beneficiaries to navigate the post-probate process. After the probate process has concluded, beneficiaries of an estate may find themselves navigating a complex set of procedures and responsibilities in order to receive their inheritance. To help beneficiaries successfully navigate the post-probate process, here are some key tips to keep in mind. Understand the final distribution plan. Once probate is complete, the executor of the estate will distribute assets according to the terms of the will or the laws of intestacy, if there is no will. Beneficiaries should carefully review the final distribution plan to ensure they understand how and when they will receive their inheritance. 2. Communicate with the executor. Beneficiaries should maintain open communication with the executor of the estate. If there are any questions or concerns about the distribution process, beneficiaries should feel comfortable reaching out to the executor for clarification. 3. Keep detailed records. It is important for beneficiaries to keep detailed records of all communications, documents, and transactions related to the post-probate process. This includes copies of any correspondence with the executor, receipts for any inheritance-related expenses, and records of any inheritance received. 4. Meet deadlines. Beneficiaries should be aware of any deadlines associated with the post-probate process, such as deadlines for submitting paperwork or signing documents. Failing to meet these deadlines could result in delays in receiving an inheritance. 5. Seek legal advice if needed. If beneficiaries encounter any legal issues or complications during the post-probate process, it may be beneficial to seek advice from an experienced probate attorney. An attorney can provide guidance on how to navigate any challenges that arise. 6. Update. Contact information. Beneficiaries should ensure that the executor and any other relevant parties have their current contact information on file. This will help ensure that beneficiaries receive timely updates and notifications regarding the distribution of assets. 7. Be patient and flexible. The post-probate process can be lengthy and complex, so beneficiaries should be patient and flexible as they navigate this phase. Delays and unexpected obstacles may arise, but staying calm and adaptable can help beneficiaries successfully receive their inheritance. By following these tips, beneficiaries can navigate the post-probate process with greater ease and confidence, ensuring a smooth transition as they receive their rightful inheritance. As we wrap up this journey through the probate process, remember that finalizing an estate doesn't have to be overwhelming. By addressing any remaining issues, ensuring all debts are settled, and obtaining court approval, you'll be closing the estate with confidence and care. Whether you're an executor striving to fulfill your duties or a beneficiary awaiting closure, this final step brings peace of mind to everyone involved. If you've made it this far, you're almost there. So take a deep breath, follow through on these steps, and know you've honored your loved one's wishes. Don't forget to seek professional advice when needed, and trust in the process. Thank you for joining us. Here's to successfully closing the estate and moving forward. Be sure to subscribe and check out the rest of our probate series for more insights on estate planning, probate, and everything in between.